I have been sitting in this courtroom for a long time, long enough to know that authority is not something you demand, and it is not something you enforce with volume or fear. Authority is earned quietly, over years of consistency, restraint, and fairness. I have watched generations pass through these doors. I have seen laws change, policies shift, and public opinion swing wildly from one extreme to another. What has never changed is the responsibility that comes with this seat. This courtroom is not a stage. It is not a battleground. It is a place where the weight of decisions carries consequences far beyond these walls. Every ruling affects lives, families, and communities. That is why discipline matters here. Not discipline imposed through intimidation, but discipline maintained through principle. When I put on this robe, I leave behind personal feelings, outside pressure, and public noise. What remains is duty. Over the years, I have learned that justice is not measured by how harshly someone is punished, nor by how lenient a sentence appears. Justice is measured by balance, by whether the law is applied evenly, without favoritism or fear, whether the powerful and the powerless stand on the same ground when they face accountability. That balance is fragile. It can be damaged quickly when authority bends to influence, or when restraint gives way to ego. I have presided over cases involving people with nothing to their name and others with more resources than most cities. In this courtroom, that distinction does not matter. It cannot matter. The law loses its meaning the moment it becomes negotiable. Respect for this institution is not optional, and it is not dependent on who is standing before me. It is a requirement that protects everyone equally. I begin every case with this understanding, not because I enjoy authority, but because authority carries responsibility. Responsibility to the law, to the community, and to the idea that fairness must be visible, not just promised. That principle guides every decision I make, including the one before me today. I have learned that privilege announces itself long before a person speaks. It shows in posture, in expectation, in the quiet assumption that rules exist for others. The defendant before me grew up surrounded by that assumption. His life has been shaped by wealth so vast that inconvenience was always temporary and consequences were negotiable. From a young age, he moved through institutions that adjusted themselves around him. Private schools, private advisors, private solutions. Problems were not solved through accountability, but through access. When mistakes happened, they were softened, delayed, or erased by people whose job was to protect his future, not to correct his behavior. Over time, that protection became belief. Belief that boundaries were flexible, belief that authority was transactional. I have seen many defendants with resources. Money itself is not the issue. The issue is what money teaches when it is never paired with responsibility. In this case, wealth did not build discipline or humility. It created distance. Distance from ordinary consequences. Distance from people who live with the results of their choices every day. Most individuals who come before this court arrive alone or with a single attorney. They wait, they listen, and they accept that the process applies to them as it does to everyone else. This defendant arrived insulated, surrounded by representation, confident that presence alone would alter outcomes. That contrast matters because it reveals mindset, not status. Privilege becomes dangerous when it convinces someone that the law is an obstacle instead of a safeguard. The defendant's background explains how contempt can form quietly, without shouting or violence. When a person has never been required to answer fully for their actions, accountability feels like an insult. This court does not judge wealth, it judges behavior, but background provides context. It shows how entitlement is not an accident, but a learned condition. And when that condition enters a courtroom, It tests whether justice will remain firm or bend under the weight of influence present here. I begin every case with this understanding, not because I enjoy authority, but because authority carries responsibility. Responsibility to the law, to the community, and to the idea that fairness must be visible, not just promised. That principle guides every decision I make, including the one before me today. 4 weeks ago, this defendant's name first entered my docket through a report that did not read like a routine citation. It described a decision that treated a public street as if it were private property, late afternoon traffic, ordinary people moving through an ordinary day. A marked patrol unit observed a sedan accelerating through a corridor where the posted limit exists for one reason: pedestrians. The vehicle was clocked well above that limit, then changed lanes abruptly, cutting in front of two cars that had no time to brake. A delivery van had to swerve to the curb to avoid a collision. In the same stretch, a school crossing sign stood less than a block away. Whether children were present at that exact second is not the point. The point is that the risk was created on purpose, and risk does not ask permission before it becomes tragedy. When the officer initiated a stop, the defendant did not respond like a person who understood what he had nearly caused. He stayed seated, hands visible, but his posture communicated impatience, not caution. He delayed lowering the window while he finished a call. He did not ask what he had done wrong. He asked who the officer was and why he had the audacity to interrupt him. The report notes that his license was not offered. It was placed on the edge of the window as if it were a favor. The officer explained the observed speed and the dangerous maneuvers. The defendant dismissed it as exaggeration. He referred to the neighborhood as empty, despite the cars, the van, the people on sidewalks. He implied that enforcement was optional when someone had important places to be. The officer remained professional, issued the citation, and documented the interaction with body camera footage. That first incident matters because it was not only reckless, it was contempt for the basic agreement that keeps communities safe, that none of us gets to gamble with other people's lives to save a few minutes. In this case, privilege did not simply ignore the law, it challenged it. Privilege becomes dangerous when it convinces someone that the law is an obstacle instead of a safeguard. The defendant's background explains how contempt can form quietly, without shouting or violence. When a person has never been required to answer fully for their actions, accountability feels like an insult. This court does not judge wealth, it judges behavior, but background provides context. It shows how entitlement is not an accident but a learned condition. And when that condition enters a courtroom, it tests whether justice will remain firm or bend under the weight of influence present here. I begin every case with this understanding, not because I enjoy authority, but because authority carries responsibility. Responsibility to the law, to the community, and to the idea that fairness must be visible, not just promised. That principle guides every decision I make, including the one before me today. What followed that first incident is what removed any doubt from my mind. People make mistakes, even serious ones, but how a person responds afterward tells the court far more than the mistake itself. In the days that followed, the defendant did not reflect, slow down, or reconsider his conduct. He acted as though the citation were an inconvenience that would resolve itself, not a warning. Within a week, there was another encounter, different location, similar conditions, same disregard. This time, the behavior did not involve speed alone. It involved refusal to cooperate promptly, refusal to acknowledge instructions, refusal to treat the situation with even basic seriousness. The officer's report describes a pattern that felt familiar: delayed responses, dismissive tone, and repeated references to legal representation before any question had even been asked. There was no apology, no acknowledgement of risk. Instead, there was confidence that the process could be managed. The defendant made it clear, through words and conduct, that consequences were something to be negotiated later by others. He spoke as though the street stop were temporary theater, and the real discussion would happen elsewhere, behind closed doors, with people who mattered more. This was not escalation through chaos or anger. It was escalation through entitlement, through the quiet belief that rules lose their force when enough resources are present. The body camera footage reflects this clearly. Calm voice, controlled posture, but underneath it, absolute dismissal of authority. That combination is more dangerous than open hostility because it normalizes disregard. By this point, any assumption of misunderstanding had collapsed. The behavior was deliberate. It showed a person who had tested boundaries and found in his past that they often moved. Each interaction reinforced his belief that restraint belonged to officers, not to him. That imbalance is exactly what the law exists to correct. When someone responds to accountability with repetition rather than restraint, leniency stops being corrective and starts becoming permission. The court cannot offer permission for conduct that endangers others and undermines the legitimacy of lawful authority. At this stage, the question was no longer whether a message needed to be sent. It was whether the court would fulfill its responsibility to send it clearly. I do not evaluate danger in the abstract. I measure it by the people who stand in its path. On the afternoon of the second incident, the street was not empty. A crossing guard was finishing a shift near the corner. A bus pulled to the curb to discharge riders. A parent walked a child toward an apartment entrance, keys in hand, eyes forward. None of them consented to being part of a test of skill or speed. When a vehicle enters that space with disregard, the margin for error disappears. A sudden lane change becomes a fall. A late brake becomes a body. These are not dramatic claims. They are the ordinary math of impact. The reports show how close that math came to being settled by chance. A stroller stopped short at a crosswalk. A cyclist veered to avoid a mirror. A driver laid on a horn to warn others. Each action was defensive, not reckless. What weighs on this court is not only what happened, but who bore the risk. The defendant bore none of it. He sat behind reinforced glass, climate control humming, decisions insulated by steel and distance. The people outside had no such buffer. They carried groceries, school bags, and fatigue from a workday. They trusted that shared rules would keep them safe enough to get home. I have heard arguments that no one was struck, that outcomes matter more than near misses. That reasoning misunderstands the court's duty. The law exists to prevent harm, not to memorialize it after the fact. Waiting for injury before acting is not restraint, it is abdication. When I consider the human cost here, I think of the quiet toll of fear that lingers after a close call. The hesitation at a curb the next day, the tightened grip on a child's hand, the glance over a shoulder before stepping off. These are consequences too, paid by people who did nothing wrong. This case demands attention to those costs because they fall on the powerless. The court's role is to absorb that risk back into the system, place it where it belongs, and ensure safety is a standard. It was after these events that the tone around this case began to shift, not in the facts, but in the pressure surrounding them. Calls were made. Messages were delivered indirectly. The language was always polite, always careful, but the intent was unmistakable. This was a situation that in the defendant's world did not have to proceed like an ordinary case. Counsel appeared early and in numbers. Motions were filed quickly, not to clarify the record, but to slow it. The court was asked to consider the defendant's future, his reputation, the businesses associated with his family name. There were suggestions that prolonged proceedings would benefit no one, that discretion, exercised quietly, could spare inconvenience on all sides. None of this was overt bribery. Influence rarely is. It arrives wrapped in reasonableness, in concern, in appeals to efficiency. The implication is always the same, that resources create alternatives, that accountability can be reshaped into something softer if enough leverage is applied in the right places. I have seen this tactic before. It relies on fatigue, on the assumption that institutions eventually yield to pressure. It assumes that authority is flexible when confronted with prominence. What it fails to understand is that this court does not trade outcomes for comfort. We do not weigh bank statements against risk to the public. I made it clear, through formal response and measured tone, that the process would not change. The facts would be heard. The record would stand on its own. No donation, no favor, no association would be considered relevant to the question before me. The law does not recognize influence as mitigation. This refusal marked a turning point. The confidence that had surrounded the defendant narrowed. The assumption that the system would adjust itself collapsed under consistency. That is often when frustration appears, not because injustice is being done, but because expected privilege is not being honored. When power meets a boundary it cannot cross, it reveals its true shape. In this case, that revelation confirmed what the evidence had already shown. This was not a misunderstanding to be smoothed over. It was a challenge to the principle that no one stands above the law. The court does not step aside from that principle, it stands on it. I have spent much of my career looking for reasons to temper the law with mercy. There are moments when a warning corrects more than a sentence ever could. I have seen fear turn into resolve and shame into change. In those cases, restraint serves justice because it guides a person back to responsibility without breaking them. This case required a different measure. The record shows not confusion, but choice. Not a single lapse, but a sequence. Each step after the first incident added clarity, not doubt. The defendant was given information, time, and opportunity to adjust his conduct. He did none of those things. He treated intervention as noise and patience as weakness. Compassion has a purpose. It is meant to restore balance, not erase it. When compassion excuses continued risk, it stops being humane and becomes permission. The court cannot grant permission for conduct that endangers others and mocks lawful authority. To do so would shift the cost of restraint from the person causing harm to the people forced to avoid it. I weighed the arguments for leniency carefully. Youth, resources, future plans. I considered them because consideration is part of the job, but consideration must answer to facts. Here, the facts show a person who understands boundaries only when they are enforced. Delay would teach nothing. Softness would invite repetition. This was not a decision driven by offense or pride. It was driven by duty, duty to the people placed at risk, duty to officers asked to enforce rules evenly, duty to the integrity of a system that must mean the same thing for every name and every balance sheet. At this point, firmness was not severity, it was clarity. The line between compassion and accountability is crossed when mercy protects entitlement instead of people. That line was crossed here, and the court was required to respond. Responsibility demanded action now, not later, and not negotiated away. I have always believed that the law must leave room for mercy. Over the years, I have seen people arrive before this court frightened, embarrassed, and ready to change. In those moments, restraint serves justice better than force. A measured response can redirect a life without hardening it. That balance matters, and I do not abandon it lightly. This case forced a careful comparison. I look back at instances where compassion worked because the person standing before me accepted responsibility. They listened. They adjusted their behavior. They understood that the court's intervention was a boundary, not an attack. Those cases shared one common feature. Accountability was present before punishment was imposed. Here, that feature was absent. The record does not show confusion or fear. It shows confidence that consequences could be delayed or avoided. It shows repeated choices made after warnings were clear. The defendant was not overwhelmed by the system. He dismissed it. That distinction is critical. Compassion requires something in return. It requires acknowledgement of harm and willingness to change. Without that, mercy becomes a shield for continued risk. When restraint protects entitlement instead of the public, it stops being humane. It becomes unfair to everyone else who depends on the law to function the same way each day. This turning point was not emotional, it was analytical. I weighed the facts, the pattern, and the effect on others. I considered whether another warning would protect the community or simply confirm the defendant's belief that limits are optional. The answer was clear. Firm action was no longer a choice between severity and kindness. It was a choice between responsibility and neglect. The court cannot neglect its duty to public safety in the hope that privilege will eventually correct itself. Fairness requires clarity, and clarity sometimes requires consequence. At this point, restraint would have communicated indifference. Action communicated responsibility. The law demands that difference be recognized and enforced. When this case concludes, it does not end only for the defendant. It speaks outward. It reaches parents who believe protection means removing consequences. It reaches those with power who mistake access for entitlement. It reaches ordinary citizens who need to know that the rules they follow still matter. Privilege is not a crime. Wealth is not a fault. But both carry obligation. The greater the advantage, the greater the responsibility to act with care, restraint, and respect for others. When that responsibility is ignored, privilege becomes dangerous, not because it exists, but because it disconnects a person from the impact of their actions. This court exists to close that distance. It does not punish success. It does not resent opportunity. It responds to conduct. When someone uses their position to endanger others, dismiss authority, and test whether the system will bend, the response must be firm enough to restore balance. Anything less teaches the wrong lesson. To parents, this case is a reminder that shielding a child from consequences does not prepare them for the world. It weakens them. Accountability is not cruelty. It is instruction. It teaches limits before those limits are enforced by tragedy. To those with influence, understand this clearly. The law does not measure worth by titles, names, or resources. It measures behavior. The expectation placed on you is not lower because of your status. It is higher. And to everyone else, know this: your safety matters. Your dignity matters. Your trust in the system matters. This court remains committed to the principle that fairness must be visible, not symbolic. Justice is not loud. It does not need spectacle. It restores order by standing still when pressure pushes. In this case, that balance has been restored, accountability has been applied, and the obligation that comes with privilege has been enforced, not ignored.